Good afternoon. Welcome to the Legal Connection with Toni and Cheryl. Toni Lynn Collins and Cheryl Ellsworth Jahani. We are here every Tuesday on 106.1 and 104.5. And also you can listen to us live on Facebook, The Legal Connection. And we are here to talk about legal topics. We're both two licensed Texas attorneys. And we're here today. We're going to be talking about expert witnesses, which I think is a really interesting topic.
Yeah, and I might add, we were going to do inverse condemnation, but we are going to do that next week. And it's a very, very important topic because it has to do with flooding, which we have a lot of in Montgomery County, and whether the government is responsible for that. And if they are, you may have an inverse condemnation claim. And in the past, they have been almost unheard of. You couldn't claim them for situations with flooding where the government might be responsible. But now, thank you.
Mom was doing that too. He had to fix it.
Now, there was just a ruling at the end of December in the federal court saying that the government was responsible for the Addicks Dam flooding. And if they open up the floodgates and you get flooded because of that. Because and we have we have the San Jacinto River, and we have many, many watersheds here in Montgomery County. And it could be that the government is at fault. And no one knew that when that happened. They thought it was just because of the rain. So the tide.
No one knew that they opened these watersheds and flooded the homes.
And they didn't know that the government was responsible for the flooding because of other things that the government did, and the city, and the county, and the state, and the San Jacinto River Authority. These different. Right. You may have a case against a government entity, and it doesn't go just toward flooding. It goes toward gas utility companies, electric companies, any sort of public utility. If they have come onto your property and taken it because they say they can, or if they do and they don't tell you, they haven't gone through the proper eminent domain proceeding, which most of the time they don't. I say most of the time. That's a real stretch. I would say that I don't know the statistics on it, but I do know that because of the recent flooding of Harvey, there was a lot of my friends came to me and I said, no way, I'm not going to represent you on an inverse condemnation. I just don't see how you can win. It's going to be too difficult to prove. And they ended up winning in federal court, that they didn't get dismissed on the various reasons that the government, with all their top expensive lawyers, had. And it's moving forward. And that was just at the end of the month, a few weeks ago.
Wow.
So we wanted to cover that in a lot of detail because we have a lot of listeners that may be affected by flooding, or public utilities taking their land, coming on and putting massive gas plants on it, a cable company putting a tower, infringing upon your property. They owe you for that by the Constitution. And so we're going to go, I've got into a little bit, but that's to kind of, wet your whistle a little bit so you can go forward and know whether or not you have a claim.
Okay, so that's going to be our topic for next week. This week, we are talking about expert witnesses. The Federal Rule of Evidence 702 defines an expert to be an individual whose knowledge, skill, experience, training, or education will help the trier of fact, the jury, or a judge that's in a bench trial, will help the trier of fact to understand the evidence or to determine a fact issue. Yeah. So I wanted to talk about that definition first. So I don't know. I think it's good for the listeners to kind of know.
It's important to know why we need expert witnesses, but also you referenced the federal rule and the state rule is pretty similar. So we're going to be talking about the state and the federal rules in general here about why expert witnesses are necessary. And we were talking earlier, and I thought it was just so that people won't fall over in a dead, I'm so bored with this kind of thing. Why is it important? We were talking before we got on the show about our own experience with our clients and the need for expert witnesses and what they expect. And you were telling me about you had a situation. So tell our listeners about that.
Well, it's just it's a corporate case. It's a breach of fiduciary duty and conversion and statutory theft case where someone came in and, there were business partners that were owned. 3 people, one man and one woman that were married to each other, and then a third party, a friend. They started a corporation. The man and woman went through a divorce, and so the third party friend just basically took over the company. He seized the moment
took advantage of a situation where he knew that the other two parties were arguing, and they were both kind of
Confused and-
getting up, kind of schmoozing up to him because they needed them for a different case, their divorce case, and he took advantage of them by slowly stealing the money away, like I'm your friend to one and I'm your friend to the other, and was committing fraud. He was a very bad person. He was the devil. That's the reason we pray the St. Michael prayer, because of these little demons getting people, and they mean well because you've partnered up with them, just like your husbands a lot of times, or your ex-husband. Which reminds me, and I don't want to go off on a tangent, but did you read in the paper this weekend where this lady, that she was going through a divorce with her husband over, I think, in the Spring area, and they'd been married for over 40 years. Do you know which case I'm talking about? Okay, well, let me just finish because it goes to this to some extent. They were going through a divorce. They were separated. Real nice house. He was going to come over and pick up some of his stuff. Pretty standard.
Right.
But he showed up. She was 68 or is 68, and he was 66. Kind of give you a little foreshadowing of what happened. And he came over to get his stuff in his girlfriend's car. But he also had planned to go to lunch with his estranged wife. So she's probably thinking, oh, we're going to talk and we're still good. We were married for so long.
Right.
But I'm sure his younger girlfriend and her new hot wide car that he's driving up in, when the wife saw this, she, as they say, snapped. I believe. I don't know. I'm not her attorney. I'm only reading this in the paper, so I don't have any insight on it. But she when he came in, he confronted her to get his stuff, and she admits she was mad about it. And then they got in a fight, and she was threatening him, I guess, so that he would maybe, I don't know what she was thinking, but she said she had a temper, and she shot him in the stomach, and he died.
Oh, gosh.
And why does that lead to our expert witness? Because it goes toward when you believe that you know somebody very well, and when you're married to them or you're in partnership with them for many years, that you have so much trust with this person, and then suddenly you're done wrong, and that trust goes out the window. There's a lot of emotion involved.
Yeah.
You cannot believe that this person that you had this strong of a relationship with, such a strong trust, which is the most important thing in life, is trust with somebody. So they would do that. That's when things go wrong, and they stab you in the back, and they dupe you, or they do something that's not in line with what you believe. Then it can get violent. It can get things that you don't expect to happen,
right.
like what happened this weekend with this woman. And I'm sure this is what happened in the case that you had. These two people were married. They had a really good friend. They started a business. The trust went down the tubes. And then this guy got possessed by the devil. Or
And
maybe
just
it
took over
and started taking...
seized the moment.
And then with their good graces, because they weren't watching, because they trusted him, he went about the business of stealing everything by, I think, transferring stock without telling them.
Into other companies.
And then pretending like the stock was worthless.
Exactly.
After he transferred it, saying the company stock that's because he was shifting assets, which happens in divorce. And a corporation and a partnership is not unlike a marriage.
Right.
That is the way the court sees it. You got into bed with them, you did a deal with them, then you have to live with what you've got. And that's what we have here. And that's why
I needed the expert.
we need an expert, because the expert, unlike lay witnesses, is and I'm just going to throw this out here. Attorneys and parties do not get to choose their lay witnesses, or their parties for that matter. You get to choose who you can go to corporation with, but you don't get to pick who your witnesses are, who your fact witnesses are.
Right, who saw what and all of that.
The fact witnesses will be the people who happen to be on the scene at the time, who are involved in the case, who are going to come forward and tell the jury, not hearsay, but what actually happened, what they know. The same is not true for an expert witness. Within the boundaries set by the relevant evidentiary standards, lawyers are free to choose their own expert witnesses. And the attorney can emphasize not only that an expert witness's qualifications to discuss key issues, but also choose a witness with strong communication skills and the appropriate demeanor. The bottom line is, you finally get to bring somebody in that doesn't have anything to do with the case, that's going to tell the judge, you can't just bring somebody in to talk about it. They've got to be an expert. They're going to sway the jury or sway the judge with information that's going to help your position of the case. And the reason we were talking about this is because we have many, many cases that we banter over with each other as consulting attorneys on what I'm thinking about our different experts, not only what experts we need to use, but how our clients feel about them and how
Yes.
very expensive they are generally.
Right.
You know, you might be able to get somebody, and that's why I ask my clients, tell me if you have a friend, even though it's not going to be biased if they're an expert. It doesn't matter if they're even your husband or they're an expert, because they're not. If they're an expert, they're not going to taint their profession by saying something that's not
Right.
true.
Right.
But
hopefully, I mean, yes.
But if when your witnesses are when your clients need an expert, and they absolutely have to have an expert in the situation that they're in, there's money involved, and that is where they are thinking they're spending this money and the expert's going to win the case for them.
Yeah.
And that's simply not the case.
I know.
The expert may be what prevents you from losing the case, because the other side has an expert that is going to tell the judge all these wonderful things, whether or not they're true or not. So you're going to have to either work with that witness or get your own expert that's going to massage it. So, go forward. I was talking about it because I'm telling our listeners why experts are important, and why you can't expect paying for an expert to win your case for you.
Yes, I think you said that to me a little bit earlier today, and I think that's absolutely true. People think when they pay money, they're going to win. They're entitled to
in
win.
fact, they think when they pay their attorney, they're going to win.
Yeah.
The truth of the matter is the attorney's going to guide you through court, and they should evaluate the case before they take the case. And it may be that you need an attorney one way or the other, but it's just like my court appointeds are like, I need a free-willed attorney because the court appointed's not going to help me. The court appointed will help you, but the court appointed is also biased with the judge because the judge has appointed them. And the court appointed may be a little bit more real than a free world attorney, as they say, because the court appointed is going to say, look, let's just cut to the chase. You're going to lose this case. But I've also seen 75% of the court appointeds, which is really sad, they've got so many cases they don't really look at the facts and they're going to run it through. But you don't get a court appointed in a civil case, and that's what we're talking about right now with an expert. You do need experts for your criminal cases. You need a gun expert. You need a psychiatrist. You need a lot of things. But
in personal injury cases too, you need medical experts and crash experts.
Yes, you need all kind of stuff like that. But in a criminal case, you may be able to move for the court to pay for the expert if you have an indigent client. Whereas in a civil case, you don't get that beauty. Mm-hmm. There's not going to happen. And you've got to also not just pay an expert. Your attorney's got to find the right expert, not just some throw down. Well, I've got an expert, because they may get disqualified because they're not qualified, or they may not be the exact expert that you need. So anyway. That's why I'm trying to make our listeners understand that experts are critically important.
Right, and it's important to hire the right expert, too.
Mm-hmm. Okay.
Also, how are you going to pay for them? Sometimes your attorney's contract will cover that, and then they will take the payment for the expert out of your retainers.
I rarely see that your attorney's contract will pay for it. More what happens is like you have with the Rachel Brown case, and with high-dollar attorneys, or just kind of the standard, is your attorney may guide you to the proper expert, but you're going to pay that expert directly. Mm-hmm. They're your expert. They are just somebody. Your attorney is going to suggest to you, this is why you need an expert, and and it's up to you whether or not you want to pay for it. You can't make your client pay for an expert, but you can tell them why it's important and kind of give them the lay of the land on. If you don't have an expert, like a case that we just went to trial with, then you may not be able to bring information forward about the case to present to the jury what the actual law is. For example, let's just talk about medical. It wasn't the case that I had, but you're going to need if there was a problem with the operation and a heart surgeon was the one that did it, and they sue everybody. They sue the anesthesiologist, the heart surgeon, the nurses, the hospital. Everybody's gotten sued, everybody with deep pockets. But you're going to need an expert that is contrary to the actual heart surgeon, depending on which side you're representing. Let's say you represent the injured party. Mm-hmm. You're going to need a heart surgeon that says that doctor made a mistake. What if that doctor didn't make a mistake? What if you just have an expert that wants to make some money, and once they get into it, or maybe they didn't have enough facts and they found out they didn't make a mistake? Well, you can't ask for money back from your expert because they didn't know. What if they decide that the heart surgeon did everything right? Now they've flipped sides and you paid for them. they haven't even helped you. Maybe this client that you're representing was of such ill health that they shouldn't have had the operation at all, and it may have been the heart surgeon for saying to have the operation, but it may have been something else came up. There was a previous operation that wasn't disclosed. Whatever the case may be, it may be that you paid your expert, and it may not be the case at all. But in the case that we recently had, or that I had, that you were sort of observing for me when we picked the jury and what have you, we needed to have an expert because we did not get to bring in some information about a real estate deal without a real estate expert coming forward and explaining the law to the jury, because that's the only way the jury was going to learn it. So that's kind of where we're at.
And so, having said all of that, I think what you just described is that in your case, if you need an expert, you need to give yourself time to find the right one.
Right.
You can't start at the last minute.
You can't wait for that designation of expert deadline to be right there and say, or it could be either the attorney should have given you your docket control order, given you some time for it, but you should be communicating with your attorney to determine when that is due. And if you're dragging your feet because you don't want to spend the money on an expert, which is what I always encounter.
Well, and the problem is the attorney waits, and then when the attorney knows it's time to really start, then the client starts dragging their feet.
Because they don't want to pony up with the money.
Yeah.
And they're like, but this is kind of the dialogue. We need an expert. Oh, well, can you find me one? Yes, here's a list of 100. It's going to be a $5,000 retainer or a $10,000 retainer, whatever the expert wants. It may be that you may be able to negotiate with them. Oh, and then the client says, oh, no, I've got lots of friends that can do that. They're experts in that area. I can find it. So you wait, and they don't give it to you, and you wait, and you're like, look, I need an expert. Then then they don't give you one, or the one they give you is completely not unqualified or disqualified. And you're like, okay, we really need an expert. But you told me you would help me. And then they lay it on you. And it's like, no. And then you have to reel it back in again. You keep everything kind of on the a nice kind of civil level. No, you need an expert, and I'm giving you the opportunity to pay the one that I'm suggesting. It's just like when you buy a house. You want to get someone to inspect the house, but the real estate agent can't tell you who to use. They can only make suggestions, or there's a bias. And so you give them a list, but they always shy away from the money. Or once they finally use the person that you give them, they believe that they're going to win the case because they put this money out.
Right.
And you haven't been paid, but they don't want to pay the expert. And then, hey guys out there, all clients or potential clients, these days you can use PayPal, you can use credit, experts can be paid, you can work out a
Credit
payment plan. But do not wait until the last minute and then, cry me a river because you don't have an expert, and then you can't lay it on your attorney. But I will say this, if your attorney has not given you the expert that you need and the opportunity to choose from a pool of them, then the attorney's at fault too. If you miss your expert deadline, without question, if maybe by just a few days, you want to request leave of court to put your expert in. More than likely, the judge is going to allow you to put the expert in if you're a few months out and you're just a few days missing for one reason or other. Stuff like that happens all the time. So don't think, oh, woe is me, I don't have an expert. No. As a good attorney or somebody that needs one, or if you're watching your own case, know that if you need an expert, then you need to be looking for it up front, timely. Expect it to cost some money. This is not free. Experts, just like you and me and anybody else out there, like our station manager, Dick, he was an expert on a radio station case. It's their time too. You shouldn't expect them to do anything for free. Time is money.
Toni, talk about this. We've talked about this before, that some clients or just individuals out there are under the impression that you can designate an expert without a retainer. And sometimes if you're friends with that person or whatever, they'll allow you.
I do it for my clients all the time, and it's not fair to the person that I designate. It's because...
Well, you told me about a case you had one time where you did that, and the expert was very upset.
Oh, no. Well, in that case, what happened was, and they had a right to be upset, to the extent that I was referred to this expert by another DWI attorney and had spoken briefly with the expert, was under the impression that she was on board. I listed her as an expert and then gave her a copy of it. Well, she didn't pay attention to any of that. And then when I went to go talk to the DA said, well, have you met this person? I'm like, yeah, they're an expert. Well, she didn't know, she wasn't paying attention. She didn't know I designated her. And she was offended. She's like, you didn't pay me. You didn't retain me. We have no contract. But my understanding was that I had retained her and we had talked and everything was fine. So the bottom line is you better have an agreement, and generally it should not be oral. It should be a written agreement, and there's a price per hour. And what I usually encounter is not, a friend of a friend. I usually like to get my experts by referral because they're good experts, and I know they've done well in court before, and I can usually read what they've done and see what kind of experts they are, how they present, and that kind of thing. But what happens is a lot of times I will. Well, no, this is a lot of times, and it's not because it's what I want to. It's because I get in a bind, and I'm trying to be good to my clients, and I'm not being as good to my experts. They're my friends. These experts are my friends, and they're the friends of the clients. And everyone thinks, oh, kumbaya. We're just talking. That's not the real world. Time is money. Every minute counts.
No kidding.
You can't be like, you're my expert and we're just going to go to lunch. That lunch is going to cost you. They're not your friend. They're your expert at this point. If they're your friend, maybe a relative or something, and they're helping you, that's one thing. And even then, they're giving up their time. So you have to approach an expert as though this is business, like a mechanic for your car. They're your friends, but they're charging you. Not be shocked and dismayed when you get a bill from them because they're doing you a favor. This is time out of their life. So there has to be a pretty good understanding of a lot of things when you get an expert. What you need them for, are they the right expert for it? So you're not going to be charged generally if it's a consultation to find out if they're the expert you need. And then what if you find out, I just had this happen to me. These people said, no, I've got an expert. I want to pay an expert. And they give me the expert and they give me the resume and everything. I'm like, great. Then I find out that their expert had been, their license had been revoked. They weren't even practicing what they were supposed to be an expert for. How is that going to look to the jury? This person is supposed to be an expert, and yeah, stuff happens, in people's life. They may be a really good expert, but I think that if the other side's got a state appointed, witness that is, that's got the graces of, the state and the governor and the president and all that, the jury's going to believe them over they're going to believe your expert that's been, their license been revoked on whatever their field is. So,
oh gosh.
so this is what you get. It's
this was the expert they gave you?
Yes, and I'm like, I could have gotten you an expert, but they didn't want to pony up the money.
Right.
And so it's like, you get what you pay for. Just because I'm helping you, and then they always say when they haven't paid their bill or whatever, you're my guardian angel. I'm like, I'm not your guardian angel. Believe me, I'm no angel.
Yeah.
As much as I hope to go to heaven and someday be a saint like anybody else that makes it to heaven, that's a long time coming. I expect to live another 50 or 60 years. To about 110, 120. and I do
good.
I do the best that I can, but this is business for them too. And when your client relies upon you solely to get them out of the what they got into, you're a plumber, so to speak, just like your client right now. They've hired you, and you're trying to dig them out of a mess. Maybe it wasn't their fault they're in that mess, but more than likely they had some part in it. Your case that you're referring to just now, this client got into a partnership, so to speak, even though it was a corporation, got into business with her husband and a good friend. That wasn't your fault. She chose those people.
Yeah.
Okay. And so now she's expecting you to dig her out of the ditch here or whatever, and to do some plumbing to clean out the mess that she's made. And you're doing the very best you can to find the best expert you can and to guide this person. And it all goes back to the core of she got herself into this. Right?
Right.
Okay. So back on track on experts. I didn't mean to go off on a tangent like that, but I think it's important that you don't hear this, you don't read this, that your expert is somebody, really the best expert you can get, may be the best bang for your buck in a case. On the other hand, it may not be. You may be able to use the other side's expert because their expert is as highly awarded and declarated as they may be. The facts just may not be on their side. And we're going to talk about that a little bit too. Expert flipping is what it's called. Switching, side switching.
Yeah, I think that's interesting. Well, okay, so just a few pointers here. When not to hire an expert witness, when you don't need one, when all that is relied on by the trier of fact, which is the jury or the judge if it's a bench trial, are commonly known things in a in the community and in a person's thinking. But if you require an expert, we talked about that before, medical experts, this case that I'm talking about, the breach of fiduciary duty.
You wouldn't even think sometimes you would need an expert in these fields, but these days you do. I think back in the time of Lincoln, there probably didn't need a lot of experts because everything was. I mean, Lincoln didn't even go to law school; he just interned. We're talking about Abraham Lincoln.
Are you kidding?
Yeah,
I had never
he didn't
heard
go to law
that.
school, right? And he interned and became an attorney, and that was like what Kim Kardashian was trying to do. I don't know how she's going to do it with Kanye on the Bible Belt track and with all those kids and what have you. But in California, you can become an attorney by interning for a lawyer for 3 years. You don't have to go to law school. So,
wow.
Yeah, things.
I mean, I
things,
know
they
that
have a change.
Yeah, they sure have. Okay, so picking the right expert, focus on the background and credentials. I think you've really covered that. Waiting too long to hire an expert. One of the worst things if you wait too long is that when you're 3 months out from trial, you'll get an expert tell you really don't have a case. This person
exactly.
Yeah,
and that is
you
something
kind of
I wanted to
touched
hit
on that.
It is a well-chosen expert provides to a case. The benefits a well-chosen expert provides to a case aren't all apparent at first glance, and an expert witness is important because they may be able to tell you maybe too far down the pike whether or not you actually have a case, and that's why selecting the right expert is vital. If you get a bad expert, they may be dragging you along, and then you find out from maybe their expert, the other side's, that you didn't have a case at all because something's going to come up. So that's really, really important. As far as expert witnesses, they can also be intermediaries within the case, and whether or not you want to find out if you want to settle this thing, because you want an expert witness who stands, who takes a stand, has grounded his or her opinion in specialized knowledge backed by a standard that can be evaluated independently of that particular expert. And as a result, expert witnesses bring a sense of objectivity and consideration to the court proceedings that can play well with juries as well as your own client. Because we're just attorneys. We're not an expert in all these different fields.
Right.
And the law is changing, and the technology is changing all the time. So how are we supposed to know this until we get an expert to tell us about that, nanobite or bleaching stuff? For an example, and I'm just going to throw this in here. I have a case right now that I did not know this, and I didn't need an expert, but I guess because we're not going forward because it was expert enough when I heard this. I am doing a criminal case where my guy was accused of going into cars, and I'm not going to give away his case or anything, but he was falsely accused of working on a car and replacing a part that at the request of the owner, and because the car wouldn't start. Okay. But what I learned while doing this was that there is a racket if you leave your car door open. So anybody that thinks, oh, my car's old, if the lock's not working, or maybe your lock thing is your little thing that you click, it doesn't work. Do not under any circumstances leave your car door open, people. Okay, I didn't know this because I'm a car door open kind of person. I'm like, people are honest at church. They're not going to steal, in the church parking lot or whatever. No, if they can get into your car, they can pop your hood. And if they can pop your hood, they can get to your what's called the computer. It's an engine module. That engine module these days regulates everything, including the theft device. And what thieves do is it's a kind of a two-step process. Somebody will go into your open car in the church parking lot where you don't think anybody's going to steal from you, and very quickly, this is a fast thing, they go in and they replace this module with one that the controls starting the car. It's that quick. And then they go steal your car. And it's usually in late model cars, 2017s, 18, 19.
Really?
And usually GMCs and trucks because those are high dollar.
Yeah.
They can get rid of they need the parts now. So your beautiful cherry red brand new truck, if you forgot or let your kids borrow your car and they leave the car door open, then this module can be changed and within they can steal it almost instantly. And it's almost impossible to prove that the module's been changed. So that goes to needing an expert witness. I wouldn't have known that.
Yeah, no
How
kidding.
are you going to catch the criminal?
Yeah.
You don't know this.
Right.
Anyway, that goes
So
to...
that goes to not being within the purview of common everyday knowledge.
Yeah, you would know. You and I would know as female attorneys. You probably are not underneath the hood of a car.
I'm not.
Every day, knowing that these days cars have this computer module that is really easy to change out.
Oh, wow.
And if you leave your car door open, but I wouldn't have known that. And if I had not had a bunch of clients who are kind of involved in the criminal area, those were my experts, the real experts, and they told me this is what you want to look for.
Wow.
So I was in the know. Okay. So anyway, as a result, expert witnesses bring a sense of objectivity, like I was saying, when presented alongside a string of eyewitnesses, which you have in car theft cases, and are in a case where somebody's in the operating room and maybe they left the sponge in or whatever. An expert can provide background information, explain scientific principles, and build a contextual understanding for lay jurors. Because what if leaving the sponge in during the operation wasn't the cause of your problem? You need an expert because, you would think automatically somebody left the sponge in during the operation, which was a lot more prevalent than you would think.
Oh, I know.
I had no idea, but a lot of times that's not the problem. It's something else. They didn't. If so busy they left the sponge in, it's something else, and it may be if they have a long operation, it may have been a different medical professional altogether. Often, what develops for jurors is a sense that the expert is grounded in reality. If you have the wrong expert, they're not. Particularly if the other expert comes in, like you see in all these TV shows, and they say, "No, exactly the opposite is true. And let me give you the real DNA information." He or she is not simply reciting a personal perspective, providing sound explanation as to why the opinion they offer is in accordance with the relevant field at hand. In practice, of course, the expert is stating an opinion, a point often worth emphasizing on cross-examination. So if they're expert saying something, you better have a bigger gun, so to speak. You don't want to bring a knife to a gunfight. You want to bring a gun to a gunfight. And if they've got if you can cut some holes into your expert, and your expert may have some information that they don't have, then on cross-examination, you can take this award-winning, governor-appointed expert and ditch them and leave them in the dust if you've got a good expert. And they don't have to be the best and well-trained expert as long as they've got the information that's going to win your case. By connecting that opinion to relevant general principles, however, the expert builds a bridge between their side's perspective on what happened and the real world in which jurors find themselves, so jurors can understand, which also goes toward communication with your expert. If you've got a brainiac who can't communicate with the jury, you're not going to win. Goes with attorneys too. You need the jury has got a complete control over your case. The judge maybe have some bias because she knows the attorneys and that kind of thing. But if you get a jury trial, your experts, it's critical that they be able to communicate with that jury, not just be some egghead with the little, mojo jojo brain thing going back and forth. The result can be powerfully persuasive testimony that has the feel of objective reality. Anyway, kind of stopped you in your tracks here, but the reality is that's so important that you have the right expert. And experts that you think you're paying a lot, they may not be the right expert. You go into this book and you find you hear attorneys have this, pick from the expert
witness.
No. You need to find an expert that is not just a professional expert, but somebody that's kept up with their field, that's why I like to get referrals. But you also have to keep them within your budget. You may be able to find an expert right out of college that wants to do you a favor, but maybe not. And that's when your client can help you. If you're on a tight budget, it could be that your client can do legwork to find the best expert for you and take that out of the legal fees when trying to find them
true.
by saying, I'm going to go to Rice University and see if they have an expert on this field. I'm going to go to University of Houston and see if they have a graduate student that wouldn't mind for a lower rate that has the credentials and can ask their professors of everything's going on if they can be an expert. But that's why you have to start early too.
Right.
So, and
that takes time.
all my clients are always trying to save money, and they can save money and I tell them every time, you can do some of the legwork yourself. If you go do this and find an expert, don't rely upon me. But if they don't, then I'll give them a long list, and I've usually tried to qualify them, but they may be very expensive, and they may be able to find their own.
Right. Okay, so what is the difference between an expert witness and a consultant? Consultants, you have consultants in cases and you have expert witnesses in cases. Expert witnesses testify. Consultants don't.
Okay.
They don't have to be disclosed. They can be secret.
Right. And a lot of times you want that consultant because you don't know what the case is going to be. You don't know if you're a winning case. you need to consult, and you got to pay them too. It's not just, hey, I'm
Yeah.
going to call my buddy over here, because you may not know anybody in that field. So consulting expert witness is very, very important, because you may not want to go forward with that particular witness. That's why you don't want to have a throwdown witness. You don't know what they're going to say. They better be consultant first. So what happens next?
Well, they can be retained as a consultant, and it's possible that they can switch over to a testifying expert witness. And expert witnesses can also be switched over to consulting witnesses. I just drafted a contract that had all of that in there. If I want,
So you want to pull them back from being an expert where everything's disclosed.
maybe something, maybe they discovered something that you don't want them to testify about, and so you pull them.
Yeah.
But you were going to talk about crossing over and
Switching sides,
Yeah.
yes. And there's a couple of different articles on it. I know that I've had some experience with it, but it's when, and this is like in murder trials, and when I had a gun expert, and you're basically they get up there, and everything's going well, and then there's some cross-examination, and because they're experts and they want to be truthful to the jury and the judge, you're watching your case fall apart before the jury and the judge, because they're just honestly answering the questions, and so you're going to have to mitigate that. But what happens when that happens? You hope it doesn't happen at the trial, because you want to be able to have that. You want to be able to have to foresee that happening. So, so long as there are lawsuits, there will be opposing experts with equally impressive credentials hired to express contrary opinions for the side that brings them to the dance. Okay, and that's what that if you do have a really good expert, the other side's going to break it down. They're going to try to make them look like trash, because they're not making your position look good. Okay, but what do you do when your opponent discovers that, like most honest experts, yours concedes that there is an on the other hand side to the opinion? So they've kind of neutralized something you paid top dollar for. It's your winning case. You're going forward. This is a smoking gun, so to speak. It may not even be the gun. That's what was in the murder case, was that the gun didn't work. And then it ends up that I couldn't use him because he was saying, well, the gun worked perfectly. It's like, that is not what my client said. They said it didn't, and there was no time to get a new expert. So I had to use their expert, sort of side switching, so to speak. Now, because their side didn't say the gun didn't work. Mine did. So I had to get rid of him. I loved him to death. He was being honest with me. Suppose your opponent decides that they like your expert's testimony so much that they want to offer it in their case. Ladies and gentlemen, don't take my word for it. Take the words of the expert retained by the defendants themselves. What a beautiful thing that would be. I don't know if it happens a lot. You see it on TV a lot. The distinguished doctor whose credentials are so unassailable that they agreed to pay $1,000 an hour for his opinion, and they do charge up to more than $1,000 an hour. And he dutifully came up with the opinion that they happily paid for. Then he conceded that there is an other hand, okay? That's bad. You don't know what opinion they're going to write because you waited too long to hire them, and then they come up with an opinion because they're being honest that doesn't really help your case. Then what do? Well, they better be your consultant first, that's for sure. Now, you know that under the federal rules of procedure, you have no obligation, absent a showing of exceptional circumstances, to disclose the identity, much less the opinions of experts retained in an anticipatory litigation who are not expected to be called as witnesses. That's what we just talked about, the consulting witnesses. But what happens once you disclose the expert as a trial witness? Can you take it back? Can you stop your opponent from using that witness by saying that you no longer intend to call them as a witness? Your case management order requires that the parties simultaneously disclose the identities and general subjects of expertise of witnesses, with reports to follow 30 days later. So suppose you designate Doctor Who, I love all of these old movies, but decide not to use him as a witness before filing his expert report. Can your opponent, Mr. What, serve interrogatories to find out what Doctor Who was going to say that got him delisted? Suppose you decide not to call Doctor Who after submitting his report, but before his deposition. These are all things you have to question, because we've all been in this bind to some extent before. Hopefully not your defendants, but I'm giving you a heads up, as well as your defendants and our station manager, who one day might need an expert witness. Can your co-defendant, Miss I don't know is the name here, nevertheless compel a deposition? Who's on first? Once the report is filed, the expert belongs to either side. Actually, the answer is far less complicated or amusing than an Abbott Costello sketch. You can change your mind and shield a witness from discovery after disclosure and before a report is tendered. But once an expert's opinion are disclosed, they are fair game and can be used by either side. Which makes perfect sense because the expert opinion is filed with the court. Like, for an example, medical malpractice, the expert opinion must be filed within 30, if there's a 30-day limitations period. Once you disclose them, they have 30 days to file their expert opinion. And if it's not filed, you lose your case. It's absolutely, your case is going to be dismissed if you don't meet that 30-day deadline. So you better know what they're going to say before. I mean, you're playing with fire here. You better have a good expert, and you better consult. And this all has to happen right, maybe before you file the petition, for that matter. But the problem is, when you file your petition, you may have a 2-year statute of limitations on medical malpractice, so you have to file a petition. So you got to be moving pretty quick here.
Yeah.
The mere revelation of a name of the witness doesn't preclude a change, of course, because the disclosure under the federal rules requires both disclosure of the identity of the witness and an accompanied writing report containing their opinions. But the report is the point of no return. Okay, you can disclose and you can yank it right back again, but that report is everything. So you're going to be talking to your witness before this report is rendered. You're going to be looking at the draft report and asking a lot of questions to your client and to the expert, because you don't know the facts. It could be that your expert's got an amazing opinion and he's exactly what you need because your client hasn't given you every fact. So you're gonna the client may clear it all up for you, and then you're on the road to perdition.
The road to perdition.
Okay. Prior to 2009, the prevailing view was that one could change one's mind at any time. If a designating party withdrew its disclosed expert as a witness, the witness was magically reconstituted as a consulting expert, immune from discovery. But Judge Frank Easterbrook of the U.S. Court of Appeals in the Seventh Circuit, and it's going to apply here also, and we're in the Fifth Circuit, took the magic out of the equation when he held a witness identified as a testimonial expert is available to either side. Such a person can't be transformed after the report has been disclosed, which we just said. Now, if it happens to you, be sure to ask for a motion in limine ruling that no mention can be made of who retained the expert. It won't take all the sting out, but it will help. It will help you once that expert opinion is disclosed. And you may not win it, but the judge may, because it's such a bias, allow you not to show that you are the one that retained them. However, if you forget to ask, and I hope you don't assume that the appellate court will fix it, since courts find it is error, but not reversible error, to allow the opposing party who called the other side's expert to elicit testimony about how the witness was retained. So you're not out of the woods completely, but it's a kind of a mitigating factor for you. So it's a good idea to depose experts after all. I have written in prior cases that I've helped some people with about the calculation of taking an opposing expert's deposition. And I've cautioned that you should twice think about doing it, since you are far more likely about taking the deposition to expand the permissible scope of the expert's trial testimony than you are to learn something useful. So depositions can be helpful. I don't like depositions, as I've told you before, unless I'm on the other side deposing the other parties' witnesses and experts. I don't like my own to be deposed because I don't know what they're going to say yet. Something may come out. So I avoid that, particularly when the deposition is asked for by the opposing side. They pay for the deposition. So ask away. If my expert comes forth, I usually, and we can go over that on a different show on how to prepare your expert for a deposition. But I generally do not like, because you're putting them on the stand, you don't know what they're going to say. It's just like what we have right now with the impeachment situation with President Trump.
Right.
They don't want to bring more witnesses forth that weren't brought forth by the House, because they don't know what they're going to say.
Right.
It's an open, you have no idea. Silence is golden. You may be better off with exactly what you've got, which I believe it's what the Senate's going to do anyway, because the House should have brought all those people. Now, if they wanted to bring them forward, they should have brought them forward in the House, because the House had the burden of proof.
Right.
Their onus. Now, this was not an original thought by me with regard to depositions of experts. I stole it from a Homer classic. But the possibility of opponents using adverse expert testimony raises a completely new issue. If you think that there is any possibility that you may want to offer testimony from your opponent's expert, then you may want to preserve that testimony in a deposition. That's why I want to depose the opponent's expert. And that's why usually people wait to the last minute to let the people know who their expert is. The court may allow you to go, but if you do miss your designation, your deadline, then you may not get to use them at all. So you can't be playing around with these experts. All right, an expert is not a party opponent, and so so we're giving you a little bit to what you need to say about experts.
Right.
And, we'll continue this.
What their focus is all about. Yeah, let's continue this next week, okay? Thank you for listening or watching on Facebook. We want to remind you to
Serve God by serving others.
see you next week, guys. Thank you.